Counsel, you're getting a little too aggressive with me. I don't want to hear this anymore from you or any other lawyer. Sounds like you already made up your mind. I heard that from you 2 or 3 times last time. I told you how I felt about this. The only purpose for me, I said I wanted to go back and review my notes and review the tape. And I told you guys you could submit other cases without having to brief them. I specifically said, I'll be glad to entertain any other cases that you have. And all you have to do is say, Judge, please read so-and-so versus Smith and cite the case. Nobody did that. I didn't receive anything. I heard your argument last time. I told you then I didn't believe there was penetration. I still believe it now. You don't like it? Appeal. But I don't like you arguing with me. And I don't like you telling me last week 2 or 3 times you're a young lawyer, but I don't like you telling me, sounds like you already made up your mind. I made up my mind based on the lack of testimony and the lack of evidence.
Okay, Judge, thank you.
Did I not, if I didn't let somebody argue, shame on me, but I don't think that was the purpose was to come back and argue. We'd already covered this. You moved the bind over, he argued, you argued.
You did, Judge, and I think I misunderstood because I think you stated to submit the case law, and I think that's where my misunderstanding was. I had case law to argue today, so that's my misunderstanding, and for that I
specifically said to you guys, don't come to court with the case law. Send the case law to me beforehand, and the record will reflect that, and I will read it. I wasn't going to burden you guys with briefing anything because I can read.
That's okay, Judge. I apologize. I got that.
I don't mind lawyers disagreeing with me, okay? It's going to happen every single day. I do mind lawyers getting smart with me. And I thought you got smart with me last week, and I don't appreciate what you just said now. What do we have as the bond?
Judge, my intention was to not
incident dates. Lisa, what do we have with the bond on this case? It looks like Judge Hessen cited a different.
Let me check. I'm bringing it.
People against Kobe Ferguson. This is file number 25B728 899. Your appearance, everybody.
Good morning again, Your Honor. Madison Oro on behalf of the people, PA 8398.
Mr. Martell.
Thank you, Judge. Good morning, Your Honor. Good morning to your fine staff. May it please this most honorable court, Edward Martell, P 85051 on behalf of Kobe Ferguson. Young man, state your name for the record.
Judge file. I think it's under there.
Right here.
Mr. Ferguson, if you haven't already, state your name.
Mr. Ferguson, state your name. State your name, please.
Ferguson.
You got to be more clear with it, sir. State your name again. I need your full name.
Kobe Ferguson.
Thank you. All right. So there's 3 counts of CSC. There's 3 counts of CSC. There's 1 count of assault with intent to commit great bodily harm, less than murder or by strangulation. Prosecutor acknowledged that she didn't prove it as to one of the counts. There were only 2 incidents here. Mr. Martell, I'm going to give you your choice. There was no proof of age of the defendant. I'm either going to let the prosecutor reopen their proofs, or if you wish to stipulate that he was born on June 1 of 23, then that's up to you. Whatever you want. If I allow them to reopen their proofs, it's going to be with respect to the defendant's age only.
Judge, we would stipulate to my client's age.
So you're going to stipulate that
to his age only.
September of 25, he was the age of, I'm sorry, as of the age of, as of September of 25, he was 22 years old, correct?
That is correct, Judge.
All right. So for purposes of exam, court will accept that stipulation. I said I wanted to think about this. I did. The testimony provided this, that the victim, whose name I'm not going to mention, was born in May of 2011 and was 15 at the time of these incidents. She attended a local high school in the 9th grade. She became acquainted with Mr. Ferguson. They had two different incidents, I should say. He told her that he was 16. She was 14 at the time when they first met. He said he went to Trenton High School, which that turned out to be untrue. But nonetheless, they had two sexual episodes in September of 25. They started doing something in the first episode, and honestly, she described her private parts as being her chest and the area from her waist down. She talked about, the prosecutor asked her some questions about what she was referring to. She said, she described peeing as being his genitalia, and she referred to hers as that. She said at one time they were both naked. He was on top of her. There was movement, she said, for 4 to 3 minutes. She said the entire episode lasted. The second incident was kind of the same. They were later at a different residence at one of her friends' houses. They were doing the same thing in the bathroom. And somebody knocked on the door saying the food was ready, and they stopped. And she said that was for 2 or 3 minutes that incident took place. There was no testimony or evidence with regard to ejaculation. There was no evidence that there was actual penetration in the court's view. The prosecutor argues that there was, because they were on top of one another, and that there was movement in the genitalia area for 3 to 4 minutes on occasion, 2 to 3 minutes on another occasion. The prosecutor cited the case of Bristol, and I just find that so different. People versus Bristol at 115 Mish Ave 236. And in that case, the victim was a 4-year-old girl. In response to questioning by the attending doctor, said the defendant's penis actually went inside, and she experienced a great deal of pain at that time in the area of the vagina. And there was an abrasion of the labia minora, which would make that, and I think the case stands for the fact that if there's penetration or some kind of penetration into the area of the labia minora, that is sufficient evidence of penetration. But there was testimony to show that penetration of the vagina to a physician would require an entry into. The point is, in this court's view, there is simply not enough evidence for penetration. There is enough evidence for sexual contact. The defendant was more than 5 years older than her at the time. And I'm simply going to indicate that I'm not binding over on CSC3 because, again, there's just not sufficient evidence of penetration. There is sufficient evidence of sexual contact, but I'm not going to bind over on that count. I'm going to bind over on 755-520E. That person, there's sexual contact in the 4th degree if the person engages in sexual contact with another person, and that person is at least 13 and less than 16, and the actor is 5 or more years older than the victim. So in this case, the age qualifies. I'm not binding over either on the assault and intent to do great bodily harm less than strangulation. Yes, the victim said he had his hand on her neck for about a minute. Yes, she said it got to be uncomfortable. There was not simply enough testimony developed to establish that there was restricted blood flow as applicable in that section that would qualify for that. So I'm simply binding over on 2 counts of CSC in the 4th degree. I'm dismissing all 3 counts of CSC. Wait a minute, let me repeat that. I'm binding over on 2 counts of CSC 4. I'm dismissing all 3 counts of CSC 3. I'm also dismissing the count of assault with intent to do great bodily harm less than murder or by strangulation. Defendant is bound over for further proceedings to the Wayne County Circuit Court. He is not in custody, so we're going to have the AOI on That would be what, Lisa? The 23rd, right?
Let me double check. Yes, the 23rd.
June 23rd. And let's see
And Judge,
here.
just to clarify, if the parties were not allowed to put, I guess, state their stance, because I wasn't able to argue anything today. I thought that was the purpose of today's proceeding. It sounds like, Judge, you just stated everything that you had already stated last week. But
So
I
let
haven't
you guys
been able
argue
to
last, but
respond to
listen to
that.
me. This was not the purpose of today. I let you guys argue last,
Oh,
listen
I
to
was-
me. Count
Up right now.
812, it looks like she said 50,000, 10%. But these are two different incidence dates. And she just referenced the other one. So unless somebody can tell me something, counsel,
Yeah, there's no bond on that 899
well, I gotta
case.
set one. I'm gonna set one now. So do you have any objection at this point? He's bound over on 25B 725-812. Do you have any objection to a personal bond, Ms. Oro? If you do, feel free to argue it.
Judge, I wouldn't have any objection at this time, though I will say at the time that the other case was in front of Judge Hessen, she did make the bond for both cases the same. I don't know if that's not showing up on the two cases,
Oh,
but she had reflected.
No, I agree with you. She referenced the other case, but he posted the 50,000, 10%. So I'm going to leave that on the other one, Lisa. I want to make sure the record is clear. There's to be 50,000, 10% on 25B 725-812. And I'm going to set on this case 50,000 personal bond. No contact with the victim or prosecution witnesses not to enter 24591 San Marino apartment 103. No alcohol, marijuana, or illegal drugs, no firearms or dangerous weapons, not to be within 5 miles of the victim, her residence or place of employment, no unsupervised contact with any child less than 18 years of age. Do you understand that, Mr. Ferguson?
Yes.
And so your date will be June the 23rd. Thank you all. Have a good day.
Thank you. Have a good day.
Thank you. Have a great one.
Maybe she didn't in the past instigate some things, but this is just wrong. "14 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, ETGs and PBTs on demand of the probation department. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm going to order that you attend the anger management program with 8-week follow-up. You're to maintain employment and provide proof. You're not to have any contact with Jennifer Fawkes. You're not to possess firearms. You are not to possess dangerous weapons. You are to pay fines in the amount of $100, costs in the amount of $225, $75 victims' rights fee, $50 justice assessment. So your fines and costs here amount to $450. Screening fee is $60 for 510, and you have probation fees of $280, bringing your total to $790. You were never in custody on this case, correct? You never were taken to the station.
Yes, it was
Were you in custody for one night?
4 nights.
4 nights? Okay. 9 days jail credit 4. I'll let you serve the other 5 on the court work program. So you're going to do 5 days on the court work program, and that is a charge of $35 a day for a total of $175. And you have plus your $790, your total's $965. If you violate, your probation could be revoked. You could be incarcerated for up to 365 days. You have 21 days to appeal. You have 14 days to apply for the court-appointed lawyer for purposes of appeal. And you may be eligible for early discharge. There was no statute that was taken under, correct?
No, you're right.
You may be eligible for early discharge. So if you complete everything and there's no violations within the preceding 90 days, you can apply for discharge. By statute, you would be entitled to it after 7 months. Do you understand that?
Yes.
All right. Do you have any questions?
No, you're wrong.
All right. Thank you very much. Could she pay all this?
No, Your Honor, can she have time to pay?
How much does she have today?
$100, Your Honor.
Okay, and you are making not much. How much can you afford to pay weekly or bi-weekly?
Probably $100.
Weekly or bi-weekly? Okay, 100 now, 100 bi-weekly. I'll give you some leeway time, so we won't start that until June the 29th. How's that?
Thank you, Your Honor.
And if you ever need more time, no problem. Call the court. We'll go on Zoom, or you can come in here on or before any due date at 8:30 in the morning. I'll be glad to give you an extension. Okay?
Judge, can I just double check her total?
Double check the total. You're probably right. I'm probably wrong. So let me,
No, you cut out at one thing, so I just want to double check.
okay, I got 100 fines, 225 costs for 325. I have 75 victims' rights, $50 justice assessment for 450. Screening fee is 60 for 510. Probation fees are 280 for 790. And I've got 175 in court work program fees, 5 days on the court work program. So the total I came up with was 965.
Got it. Okay, we're good.
Okay? All right, you'll meet with probation. Have a good day, ma'am. Do everything you're supposed to do here, please, okay? Good luck. Felsky. Thanks, Ms. Belcher.
Thank you, Your Honor.
And Michael Andrew Felsky, 26W703474.
Good morning again, Your Honor. Leanna Belcher on behalf of Mr. Felsky. Mr. Felsky should be present on Zoom. Mr.
Mr.
Felsky.
Felsky, start your video, please. Your name, sir?
Michael Felsky.
Okay, so we're going to proceed to the exam.
That is correct.
All right, so sir, you're going to have to be here in person next week, okay?
Yes, sir.
That will be June the 16th, June the 16th at 10:15 a.m., okay?
Yes, sir.
Any questions?
No.
Anything else, Ms. Belcher?
Thank you.
Thank you very much. Do you have any others?
Yep.
Have a great day. Thank you. Do I have out there yet, are they here on Ferguson?
Yes, they're all on Zoom.
Okay, I'm gonna take this one with Ms. Aycock real quick. Alexandra Boyer.
Good morning, Your Honor. Leslie Aycock
Sorry.
on behalf of Ms. Boyer.
It's 26M691425. Okay, your appearance?
Good morning, Your Honor. Leslie Aycock on behalf of defendant Alexandra Boyer with permission to stand in for her today on the civil infraction.
All right, so she's gonna plead the limited access. You're authorized to enter in that plea. Limited access, 11 to 15 over, with the understanding that 25 over will be dismissed, correct?
That is correct, Your Honor.
All right, like you said, you're authorized to enter this plea on her behalf?
That is correct.
To that charge on her behalf, responsible or not responsible?
Responsible, Your Honor.
I hope you've talked to her about her speeding. She's gonna have a real bad way to go. She keeps driving like that. 195, and I'll give her till the 16th to pay, okay?
Could she have a little more time? She indicates to me her next payday is June 26th. So that's a Friday.
June
Would it be
29th, June
Thank you.
29th, okay?
Thank you very much, Your
But
Honor.
honestly, her record, driving like that, 102 is not good. All right, thanks a lot. Have a good day.
Thank you.
All right, people against Kobe, Rashar, Ferguson, 25B. Hang on one second. Give me 1 second here. I don't need to call the one case, so I'm just going to call Kobe Rashar Ferguson, 25B 728899. Okay, everybody's appearances, please.
Good morning, Your Honor. Madison Oro on behalf of the people, PA 8398.
Where is Mr. Martell?
Judge, he was out there. I'm not sure what happened, unless this is him in the not guilty law.
Ready, Judge. Thank you.
Oh, there we go.
Your appearance?
Good morning, Your Honor. Good morning to your fine staff. May it please this most honorable court, Edward Martell, P85051, on behalf of Mr. Ferguson, who joins us via Zoom. Young man, please unmute yourself, show your camera, state your full name for the record.
You have to state your name, sir.
Mr. Ferguson, please unmute and state your name, sir.
Mr. Ferguson, I need you to state your name, sir.
I do apologize, Judge. Bottom left, sir. There's a little microphone. Hit it, please. State your name. Judge, on behalf of Mr. Ferguson, I would ask the Honorable Court to acknowledge his presence, and I would waive any further presence at this time, considering
Mr.
the nature-
Ferguson, will you do me a favor and unmute in the bottom left-hand corner of your screen? And then tell me your name.
I do apologize to the court.
Mr. Ferguson, I need you to unmute. Can you hear what I am telling you, sir? Why didn't I just have him come in person? You know, I just. Mr. Ferguson, stop, unmute your video, please.
Judge, I do understand the frustration of the court. While Mr. Ferguson was found competent, Judge, there certainly are some developmental delays. So he may be technologically impaired. I do acknowledge that that is my client on the record if your court wants to move forward.
I'd really like to have him hear and know that he's hearing this. I really would.
Judge, may we pass this matter for 5 minutes? I can call his mother.
I'll be happy to have that you do that. I'll pass it for a couple of minutes. Thank you.
My apologies, Judge. Thank you.
That's all right. I need those.
Oh, you're not the one. Just have a seat.
All right. I'm getting close to requiring the defendant to appear on that in person. If he can't figure it out, Lisa, you can tell Mr. Ferguson that he has to appear in person and make sure the prosecutor will make sure the prosecutor and the defense
It's-
lawyer can.
Okay, he just logged back in, so I'm bringing him in.
Okay.
Mr. Ferguson, can you hear us? Can you unmute and start your video?
Hello, yes. Kobe Ferguson.
Can you start your video? Okay, stay right there now. Now let's
Hello,
get the
yes. I'm
lawyers.
so sorry. My phone is acting up.
You're fine. You're fine. Don't worry about it. I just want you to be able to hear this. So let's get his lawyer in here. Ms. Trombley has a civil infraction. Do we have that one down there anywhere?
Yes, Kobe Ferguson.
Just wait 1 second, sir. Just wait 1 second. Just stay right there, please. Do you have a case that you've done with Ms. Trombley, priority waste?
We can write those up. The priority waste ones are again.
This is going to take thank you. It's going to take a few minutes, so I'll get you out of here if I can.
Thank you, Your Honor. I appreciate it.
Where is Ms. Oro and Mr. Martell?
Judge, I'm here, just waiting for Mr. Martell.
Okay, good enough. Where's Mr. Martell at now? Lisa, do we have him out there anywhere?
He's not in the waiting room. Maybe he logged off to call his client.
Oh, boy. Hey, dude. Do we have his number, Lisa? Can we try calling him? Maybe
call him.
he's. Thank you. If you want to log back on, I still don't have that file, Ms. Trombley. If you want to leave and go back to some other court, that's fine. You can log back on, but I can't, I'm not going to go back there and force him to write it up. And I'm not going to,
I have a 9:15 and 36, so I feel like I'll be stuck there. So I'll hang out for a few more minutes.
I don't know why they didn't bring it in, but I know they're busy, so I'm not going to criticize.
Yeah, no problem.
Judge, Mr. Martell did not answer. I will call the prosecutor and have him bring in priority waste.
Thank you, Lisa.
Tell them to bring in whatever they have. I got no files here. I'm not going to start those sentencings yet, John. I'm not going to start those sentencings until after I
Okay, Judge.
render this decision and get some of these other people
I'll
out.
handle someone else.
Sorry.
No, that's fine, Judge.
Morning, Dodge.
She's on her way in with priority waste.
Thanks, Lisa.
You're welcome.
I can write that down. All right, People Against Priority Waste LLC, 260-27215. Ms. Trombley, your appearance.
Yes, good morning, Your Honor. Elizabeth Tremblay appearing on behalf of Priority Waste.
On this case, this is a charge of spill load / leaking. Does your client stand mute, waive formal reading?
Yes, Your Honor.
Not guilty, please enter. Prosecutor is to dismiss. Says the defendant is in compliance with the law. The case is dismissed. Priority Waste LLC, 26SO27216 A, B, and C. Your appearance again, please.
Yes, Your Honor. Elizabeth Tremblay appearing on behalf of Priority Waste.
All right, this defendant stand mute, waive formal reading on the misdemeanor of spill load.
Yes, Your Honor.
And now, as I understand it, the prosecutor is going to dismiss that case after your client pleads to overweight with agreed upon fines and costs of $1,177, and with the understanding that the C file spill load will be dismissed and the defective equipment will be dismissed, correct?
That's correct, Your Honor.
All right, on behalf of your client, first of all, are you authorized to enter into that plea on behalf of your client?
Yes, Your Honor.
That charge of overweight violation, responsible or not responsible?
Responsible.
I'll accept the plea, assess fines and costs of $1,177, paid by July the 9th. And I'm going to go ahead and dismiss the defective equipment and defile the misdemeanor of spill load. Okay?
Thank you, Your Honor. Thank you, Your
You're all
Honor.
set.
Have a good day.
Thank you.
Thanks.
What else do you have down there? Where is Mr.
Sure.
Martell? There
Mr.
you are.
Martell's back online.
All right, now let's go. Ms. Worrell, come on here. James Truckee. James,
Ready, Your Honor.
let me call this whole case. I'm sorry, James Berg Trucking Company, 26S118457. Appearances.
Michael Levitt, I represent Jamesburg Trucking Company, Your Honor.
How you doing, Mr. Levitt? Sorry to keep you waiting. There's an overweight here. What is this charge? Exceeded posted bridge.
Yes, Your Honor, it's an overweight bridge violation.
Right, and there's agreed upon fines and costs of $3,500, true?
That is correct, and
And you're authorized to enter that plea on behalf of the company?
I am
To that charge, how do you plead, responsible or not responsible?
responsible.
Please accept it, $3,500 paid by July the 9th. People against, is this yours too, counsel?
I have
Yes.
Payola
Yeah.
Express.
Pahoa Express Inc., 26SO25075A and B and C. All right, your appearance again?
Michael Levitt, I represent Payola Express Incorporated.
All right. So what are we doing on this one? There's going to be a plea to overweight with agreed upon fines and costs of $1,700, true?
No, Your Honor, I thought the reduction would be $1,177.
They wrote down 1,700.
That would be an error.
Are you on this?
Yes.
I'm sorry, your name?
Corporal Vega with Wayne County Sheriff's Office.
Okay, you were the issuing officer?
Yes, Your Honor.
Would you do me a favor? Do you think this is an error? Do you agree with what he said?
It is an error. I was in there. I wrote the wrong fine amount, and when I first came in here, I corrected. So what he said.
I'm going to get him out of here. I'm going to ask you to take this in real quick to the prosecutor and have her change that. Will you do that for me? And then there's going to be a plea to overweight with agreed upon fines and costs of $1,177. And that's what you're telling me, correct, Deputy?
Yes.
All right, so I'll ask you to take that into her right now.
Okay.
And then there's going to be a dismissal. Let me just see here. That's on the A file, 75A. And then there's going to be a plea to Overwood, which is the C file, correct, Mr. Levitt?
That is correct, Your Honor.
All right. And they're going to dismiss the C file, right?
They're going to dismiss, I
I'm sorry, the
believe,
B file, the B
the
file.
B file, correct.
And that's defective equipment. And you're authorized hearing these pleas on behalf of the company, true?
I am, Your Honor.
All right, so to the charge of overweight on file A, responsible or not responsible?
Responsible.
To the charge of overweight on file C, responsible or not responsible?
Responsible.
All right, and I'll accept those pleas. I'll dismiss the B file on motion of the prosecutor. That's the defective equipment. All right, thank you. So we are all set. I'm gonna assess fines and costs. He's made that correction on here, 1177 on the A file overweight. I'll make it 300 on the over width, and I'll give you until July the 9th to pay on both of those, okay?
I really appreciate the courtesies this morning, Your Honor. Thank you.
Have a great day. Always a pleasure.
Yes, likewise.
Judge, do you have MacArthur up there?
I don't know. Give me 1 second, Lisa. I'm a little.
Okay.
Can you have them send my granddaughter down here, please?
Yep, she's on her way. I just told him.
Perfect. Thank you. Good morning, Mr. Haysha. How are you?
I'm doing better now that I know that there's a granddaughter in the building.
She's a lot cuter than I am, I'll tell you that.
Well, I don't doubt that for 1 second. We got to get her some screen time.
People against Robert Joseph MacArthur. This is 26G7091562. All right, your appearance.
Your Honor, good morning to you and the staff. Vincent Haysha, with and on behalf of Robert Joseph MacArthur, who's present through Zoom without objection.
All right, Mr. MacArthur, your name, sir?
Good morning, Your Honor. Robert Joseph MacArthur.
Who's this gentleman sitting next to you?
That would be my son, Robert Nicholas MacArthur. How you doing, sir?
Good. What?
Co-defendant case, Judge.
What's that?
It's a co-defendant case. I represent both of the individuals.
I think they sent in. Oh, they did. Now I also have Robert Nicholas MacArthur, 26G7091561. Okay. Your appearance again, Robert Nicholas MacArthur.
Vincent Haysha, with and on behalf also with Robert Nicholas MacArthur, who is present through Zoom without objection.
And sir, your name again?
Robert Nicholas MacArthur.
All right, so they're charged with aggravated assault. For purposes of arraignment, do they stand mute and waive formal reading?
Yes, Your Honor.
All right, now I have some concerns. Let's talk about the first one. What do you think that's going to be? Are you sure there's not a conflict?
Your Honor, I've spoken to both Robert Joseph and Robert Nicholas extensively about the aspect of a conflict of interest, about the typical necessity of having separate counsel, about the potential that conflicts could arise throughout the course of a case. I believe that they both understand and acknowledge that that is, I guess, theoretically always a possibility, but in this particular circumstance, do not believe it to be a possibility that will arise. I don't believe that there's a conflict. I think that they have mutual interests. I believe that their defense is extremely similar, and I don't think that that is something that could arise. I just want the record to be clear that it's a conversation I've had separately with father and son, with Robert Joseph and Robert Nicholas, and I do believe that they're knowingly and understandingly moving forward with the same counsel at this point.
Robert Joseph MacArthur, do you
Yes, sir.
understand everything that your lawyer just said?
Yes, sir, I do.
And do you understand everything your lawyer just said, Robert Nicholas MacArthur?
I do as well. Yes, sir.
So you understand whenever there's co-defendants and a defense lawyer is representing both, that there certainly is a potential for a conflict of interest to arise. One defendant says, I didn't do it, he did it, or anything else similar thereto. that creates a real conflict of interest issue. Do you understand that, Robert Joseph MacArthur?
Yes, sir, I do.
And Robert Nicholas, do you understand, Robert Nicholas MacArthur, do you also understand that?
Yes, sir, I do.
Knowing all that at this point, based on your consultation with your lawyer and based on what he said, do you want him still to represent you at this point, understanding that he's telling the court if a conflict arises, he will take the appropriate steps to make sure that the conflict is resolved. Do you understand that, Mr. MacArthur? Robert
Yes, sir.
Joseph?
Yes, sir.
And you still want him to represent you?
Yes, I do, sir.
And how about you, Robert Nicholas? Do you still want him to represent you?
Yes, sir, I do.
All right, now that's one concern. The second concern I have here, I don't mind them appearing by Zoom. What I do worry about is there's a necessity for me to get them printed. I mean, this is not, still a 1-year misdemeanor, and that means they're going to have to come here unless you can figure out some other way. Is there a detective on this from Gibraltar out there by chance?
Not on Zoom.
Okay. They didn't my granddaughter, where'd they take her? Do you know? John, can you go in those?
They walked down with her.
Can you bring her in here? Get her in here, please. All right. So how do you propose that we handle that? They live in Estero Beach. I mean, I don't need them coming back for every proceeding unless there's a trial, but I do need them to get printed.
I understand that completely, Your Honor. I can reach out to Gibraltar and see if there's a way that they can have prints taken out of the state. If it's not a possibility, then they'll have to make arrangements, and I'll communicate with the court, and we'll get that done in a reasonable amount of time, Your Honor. It's not something I considered prior to today, or otherwise I may have had a better answer for you. But I do think if it's something that requires them to travel, then we'll make sure that they travel and make appropriate accommodations.
I'm surprised nobody from Gibraltar's here on this today. Did they know that this was up, or did you just make arrangements to come in
This
today?
has been scheduled for approximately 3 weeks.
We need to cancel the warrants if they haven't been canceled, Lisa, too, on these.
Yeah, they have.
All right. I just don't know anything about it. All right.
The allegation, do you want me to give you a brief summary of the allegation?
Yeah, but give me 1 second.
Sure.
Who was bringing her down, Lisa? I don't
Thought
know
it
where
was
she
John
is.
Miklos.
This one. This one.
You know,
This one.
Heather,
No idea.
can you find her and get her in here? Just give me 1 second, will you please? And I'm gonna press it right now. Yeah, now you can give me a brief synopsis, if you would, Mr. Pasha.
Your Honor, the prosecutor's theory of the case is that that Mr. MacArthur, Mr. Robert Joseph MacArthur, and Mr. Robert Nicholas MacArthur were patrons at a Gibraltar establishment. That at some point during the time that they were at this establishment, that there was an altercation between the complainant and Robert Nicholas MacArthur. That Robert Nicholas MacArthur was injured during that encounter, and that ultimately Robert Joseph and Robert Nicholas, with some sort of malice and an intent to seek out retribution, thereafter attacked this particular complainant. Obviously, we disagree with that, but that is, as alleged, and what I believe to be the prosecutor's theory of the case.
What establishment was this at, Mr. Haysha?
Just one moment, Your Honor. Captain Jim's, Your Honor. I'm not familiar with it, but I believe it to be a local spot.
All right. Okay, here's what I'm going to do. You're asking for a personal bond.
I am.
Any one of these guys have any criminal history?
There's no salt of history for Robert Joseph MacArthur. In 2011, there was a neglect of duty. It was a matter that involved him failing to, it's a very public matter that involved a circuit court judge in Wayne County and a prosecutor, and a neglect of duty for failing to arrest a sitting judge and a sitting prosecutor.
Wait, say that again?
There was a very public case in 2011 in the Wayne County Circuit Court that involved a criminal defendant that was a circuit court judge. I don't want to put any names out there right now, and a prosecutor. And Mr. MacArthur, while in his capacity in law enforcement, was charged and ultimately pled to neglect of duty for failing to arrest the prosecutor and the judge during the course of that case.
Wow. All right.
That's the sole criminal history. Aside from that, Your Honor, he's been a pillar in the community, coached Little League football, baseball, and basketball in the area of Gibraltar. He was a high school coach for basketball. He owned several businesses and apartment complexes in the Gibraltar area. He's been in law enforcement for longer than I've been alive, with the Sheriff's Department, City of Northville, Inkster, DEA Task Force, Highland Park. He was a City of Detroit transit officer. He doesn't represent a danger to the community or a flight risk.
What does he work for now?
He's currently working security, Your Honor. He has 2 positions that he works for in the state of Florida.
And is he required to carry a firearm?
As a condition of work, Robert, do you carry a firearm as a condition of your employment?
I do, sir. I currently hold a Class G license, and I do work in a school.
School resource officer. I apologize, Your Honor.
And I also work for my church as a security officer for the church that I attend.
Okay. All right, look. So much paperwork to fill out. Here's what I'm doing. I'm going to give you both a personal bond of $5,000. You can leave the state. You can remain in Florida. You cannot violate any law or ordinance. You must appear in court as directed. Neither one of you are to have any contact with James L. King III. No contact with him. You cannot write, phone, see, text, email him, communicate with him, or have any contact with him whatsoever. You're not to have any contact at all. No contact at all with prosecution witnesses except through your lawyer. No contact with prosecution witnesses except through your lawyer. You are not to enter the property address at 29104 North Gibraltar Road in Gibraltar. You're not to go back there. You're not to possess any firearms or dangerous weapons. No firearms, no dangerous weapons. I'm going to allow you to continue to use those, except when working, Mr. MacArthur. So I'm going to trust that you have a place to keep that firearm on the premises, because you're not going to take it out of there. Do we understand that?
Premises, referring to
wherever you're working in law, in your capacity that requires you to carry a firearm. I'll let you continue to do that. I'm not going to take your job from you effectively by saying you can't use a firearm, but I want you to store it somewhere. I don't want it in your possession except in the course of employment. Do you understand that?
Yes, sir. I understand fully, sir. Thank you.
And as for you, that's Robert Joseph. And as for you, Robert Nicholas, you're not to possess any firearms or dangerous weapons whatsoever. I'm going to ask that I'm going to have you return to the Gibraltar Police Department to be fingerprinted and photographed by June the 23rd. I will let you appear by Zoom. If you can work this out differently, Mr. Haysha, I could care less. You know, if you can, I don't think they're going to be able to do what you're suggesting, is what I'm trying to tell you nicely. So I'm going to give them 2 weeks to get here. If you get the fingerprinting somehow done where they're here in Gibraltar by two weeks from now, and you should call Detective Robinson on that, I'll be more than happy. I'm not looking to make people travel across the country, but that's what I'm going to have here. Okay. So give me a court date if you would, Lisa, and we'll go from there.
June 23rd at 8:45.
I just want to make sure, because I don't see that. have they been canceled? Have the warrants been canceled?
Yes.
Okay, good. June 23rd at 8:45. Is that good with you, Mr. Haysha?
I'll make it work, Judge.
And I'll let you appear by Zoom too, okay?
Thank you, Your Honor.
All right. Anything else, Mr. Haysha?
Where's that granddaughter?
Right here. Want to say hi? Want to say hi?
I do. Oh, I see her right now, just on the side. Hi, sweetheart. No, that's it for me, Judge. Thank you.
Have a great day. Thanks a lot.
Take
Bye
care.
now. Bye. All right.
Judge McNally?
Yeah.
Quick question. I have Towers Trucking and I have somebody who, his job is the manager, Department of Compliance. He says he's under the precedent. Can I, because I know last time you wanted to make sure that they were either somebody who's the president to represent the trucking company.
It's got to be either an officer. What kind of case is this?
It's one of those,
Is it a
roasted bridge. I just want
Is it a civil infraction or a criminal case?
It's a civil infraction, Judge.
If civil infraction, I don't mind if an officer appears.
I just want to
But on a misdemeanor, they have to have a lawyer.
Oh, okay.
Okay, misdemeanor, they have to have a lawyer, no matter how big or small.
You have such a cute granddaughter.
Thank you.
Judge, I came in just for her.
Oh, good. When?
Now we have a princess in our presence.
I know. Thanks. Thank you. Okay. Stevie Buktalaj. 260-710812.
In charge, if you don't mind, I've got 3 sentences writing on it.
Yeah, you can go work on other things. I'm just kind of.
Okay, Judge, I understand.
Counsel, your appearance.
Good morning, Ren Lushai appearing with and on behalf of Mr. Litigation.
Your name, sir?
Stevie booked a lot.
Judge, the
Okay.
victim's on Zoom also.
Okay. And your name, sir? Or ma'am, I don't know who the victim is on this. Let me see.
It's Cassandra Gullah.
Okay, ma'am,
Cassandra
your
Gula.
name?
Cassandra Gula.
Good morning.
Good
What are
morning.
we doing on this? We're gonna go to trial?
Yes, Judge, we're still talking, and we're presuming that we're gonna be able to work it out, but in the meantime, we'd like to set this matter, if the court is available on the 24th of July, for jury trial. To move the case along.
Who's on this, Ms. Holloway? Is she good with all these dates? She said.
Yes, we worked them out together. The 24th is our preferred date. If the court is not available, then we can also.
I can do the 24th. Set for jury trial. That's what you want, right?
Yes, sir.
July 24th at 8:30. And I'm gonna set a final pretrial 3 weeks before that if I can, Lisa.
June 30th at 8:30.
Ms. Holloway, you're, please.
Good morning, Your Honor. Yeah, 8:58.
All right, that's what I'll do. Final pretrial, June 30, 8:30, July 24th, 8:30 will be the jury trial.
I'll be out of the country on June 30th. Would the court consider a couple of days before or?
Well, they're only in here on Tuesdays. And I don't want to have them sent out. If I have them in here on July this, well, I'm not here July.
You're
but-
off that day. We could do June
Of June?
23rd.
Yeah, we can do that. I just don't want them to have to send out notices if this resolves. June the 23rd at 8:30, okay? Do I need to do anything else? You guys weren't here last time, huh?
We were by Zoom.
Okay. All right, anything else? And then I'm gonna set jury instruction dates. I'm gonna ask you guys to get together and prepare the jury instructions, so I just have to read them. And if there's disputes, no problem, I'll resolve the disputes, okay? Thank you. Thanks, ma'am. I'll see you here in June, okay?
Yep, thank you.
Good luck, thanks. Song is Feng Zong, 268-6647. Where are you at, Mr. Song?
Yes.
Yeah,
well,
yeah.
60. You left it in my chambers, you know, did that. You just grab her water in the chambers there, please. All right, Mr. Song, your name?
Fen Zhang.
They're gonna go ahead and dismiss this. They say you got a fishing license down, failure to exhibit a license, they're dismissing it. Case dismissed. You
Thank
are
you,
all
Your Honor.
set. Wish
Thank
you
you,
well.
Honor.
Good luck.
Okay, bye. Thank you.
Jordan Chelsea Judge. 26R712668. Good morning.
Good morning. This is the girl with the neighborhood defender service, B86-132, appearing on behalf of Ms. Judge, who stands to my right. Say your name for the record. Jordan Judge.
So we're proceeding with the exam is the first thing. And that will be exam. It's set for next week. You can't do next week?
No, Judge, we're asking to set it out 2 weeks to the 23rd, I believe.
All right, we're gonna do it on June the 23rd at 11:30. And you understand, Jordan Judge, that you have the right to an exam within 7 days of the date of the probable cause conference, but your lawyer would like to have this moved 1 more week. You understand that? And you understand if I grant that request, that means the preliminary exam will not take place within 7 days of the date of the probable cause conference. Do you waive that right? Anybody force you to do that?
No.
All right, I'll accept the waiver. Now, I'm not sure what I'm amending. Request to affect custody text only. What am I doing?
So Judge, I did speak with Ms. Alloway. My understanding is that the complaining witness is here, spoke with the prosecutor's office and would like to amend the no contact order to effectuate contact text only, because they have children in common. So just to exchange the kids and things of that nature is my understanding. And if Ms. Alloway wants to elaborate on that.
Can you go get Ms. Alloway, please? I'm not sure I understand this. Right now, and I didn't do the arraignment on this, but right now, there's no contact with the victim, Jordan Judge. And then except to effectuate visitation with the minor children through third-party contact only, exchange to occur at the Rockwood Police Station parking lot. So nobody wants that. Your appearance?
Yeah. Good morning, we're all going to be on the people.
Okay, so did you hear what I just read? I didn't do this arraignment. So now what are you guys saying? You don't want there to have to be exchange at the police department?
Your Honor, I spoke to the complainant on this matter and she said that she would be okay with text messages only regarding custody. Apparently, the kids go to daycare, so if somebody needs to pick them up from daycare, text messages about that would be okay, so long as obviously they're limited solely to just custody.
Okay, so I'll just make a note that as of today, no contact with victim except to effectuate visitation / custodial exchange. And they may do so by text, correct?
Your Honor, yeah.
But do they still have to exchange at the police department?
This text is at this point is.
So they can have contact then?
Yes, solely.
So somebody's gonna bring the child over or children over to the other one and that's fine?
Yes, sure.
All right, so I'm gonna just delete the whole through third-party contact only. Right?
Yes, the third party that they were using is no longer available, so text messages.
I'm gonna delete that as of June the 19th. They may have contact by text and exchange in person. How's that? So that's what I'll change it to, okay? Does that cover it?
I would like to address bonds briefly, if in addition to those other changes.
What do you want?
So currently Ms. Judge is on a tether. I understand this is domestic violence, allegation, however, we are asking for the tether to be removed. Ms. Judge has no, prior criminal history. She was a police officer for 9 years. She worked in Ypsilanti and in Wyandotte. And then she actually just recently got a job with Homeland Security back in September. Due to these allegations, she actually lost that employment, and now has this tether on. So she's currently unemployed. Going and applying for jobs is very difficult. With the tether, obviously, there's a lot of stigma that comes along with tethers. Not only that, but it's costly. It costs money. She doesn't have employment, so she's not having an income. So it's a lot of negative things that are occurring. Considering that they are allowed to contact now, at least to exchange the children, I don't think that Ms. Judge is a threat to the community. I don't think that she is a threat to Ms. Judge at this point. And additionally, she has no KPS history. She is here. We've had constant contact.
This is the victim in the front row, correct? Jordan Alexandria, Judge?
And I did just confirm with the complainant, we don't have any objection to removal of the tether. Of course, with this amended no contact order, contact should just remain through text. And we have no objection, obviously, in the hopes that no issues arise.
Good. I'm seeing through text, they're still going to exchange the children together, right? Is there one child, multiple children?
To my knowledge, the way that that exchanges will likely happen is pickups from the daycare. So if, say, the kids are at the daycare, they can pick them up today. So it's likely that they really won't be seeing each other in person.
Okay, I just got done saying no contact with victim except to effectuate visitation, custodial exchange. And may do so by text and exchange in person. You don't want me to have an exchange in person?
One moment, Your Honor. That's no problem, Your Honor.
Okay, then I'll just remove the tether. Tether may be removed. All right, so Lisa, we're gonna make sure. But then there's also an order here not to be within 3 miles of the victim. So unless you have a problem, I'm gonna go ahead and delete that.
Well, given that the custodial exchanges may happen, we would have no objection to that either.
I'm deleting that they can't be within 3 miles of the victim. So she can be within 3 miles of the victim. Tether no longer required, so we're gonna have to give the county jail the notice of that, Lisa. Anything else?
Nothing further, Your Honor.
Okay. I'm making my notes here, and June 23, we'll see everybody at, what time did I say? 11:30. Can we make it earlier than 11:30, Lisa? Or not really?
Yes, we can do 11,
10:30?
10:45.
Okay.
Your Honor, the earlier the better, in the hopes that we can just get it done as soon as possible.
How about could we go earlier than that or not really, Lisa?
Yeah, that's fine.
You want
You
to
want
make
to
it
do
at
10
10?
or 10:30?
Yeah, let's make it at 10 o'clock, 10 a.m. Okay?
Thank you, Judge.
Thanks a lot. Have a good day. Good luck. Mhm.
Hey, who's in the jail?
Sir, what is your name? Can you unmute or get them to unmute you, please? And tell me what your name is?
My name is Damian Butler.
Butler?
Yes, sir.
Okay.
Okay, I'm just waiting on your attorney, okay?
Yes, ma'am.
It did? You'll like another one of those ones. You got another one? Well, they've wait sprinkle. Wait sprinkle?
You want to? You would. So thank you. Yeah, thank you.
Good morning.
Do I have anything else down there?
Miss Tucker Davis, can you join the breakout room?
Yes, thank you.
Thank you.
That's too late, but I sent one person in Towers Trucking. Is Lisa on? Should I just tell her to put that back in the breakout room with me? Thank you. Lisa, could you put Mr. Flores back in a breakout room with me? He's on Towers Trucking.
I don't, John.
Good.
Mr. Dax, do you want your client first or the prosecutor?
Can I speak to my client, please?
Okay, let me put you in a breakout room.
Thank you.
Judge, you put the waste management case
Oh,
there.
thank you. Thank you. All right. Waste management, this is, 26SO27217. Good morning, Mr. Powers, your appearance.
Yes, good morning, Your Honor. Sean Powers, P42752 on behalf of Defendant Waste Management.
All right, so this plea is charged to overweight with the understanding that the fines are going to be reduced, fines and costs of $2,100, true?
Yes, correct. Yes, Your Honor.
And you're authorized in that plea on behalf of the defendant?
I am, Your Honor.
To the charge of overweight, responsible or not responsible?
Responsible, Your Honor.
Plea is accepted. Fines and costs are $2,100, and I'll give them till July the 9th to pay on that, okay?
Perfect. Thank you, Your Honor.
Have a great day. Thank you. Do you have a case, Mr. Bukowski?
I do, Judge.
What do you have? Good morning to you, by the way. What do you have?
Good morning. Good. Daniel Gomez. Been a while, Judge.
Did you talk to the prosecutor?
I did. We'd like to set this for exam. I know we've got an exam date scheduled for next week. I'm just getting discovery, and I've got a couple conflicts. I'm hoping that we can just set this for an exam on June 30th, if the court is willing.
I doubt it, but let me get the file, okay? Let me get the file. All right. But I don't have it yet. They didn't bring it in. As soon as I get it, I'll call it, okay?
Very good. Thank you, Judge. Am I the last one?
No, I got others, believe me.
And sorry I was late, but I'm up in scenic Flint, Michigan right now. Just left a hearing, so.
You're where?
Flint.
Oh, okay. Well, that's not too far.
Could be worse.
Why they're not bringing those files? Or later. What's that? It's not. Okay. Listen. Hey, I want to get off the bench here for a couple of minutes, but I'd like to get a couple of these people out of here if any of those files have been filled out. I got Mr. Mikowski out here. I got somebody from Towers Trucking and Mr. Gomez. That I believe is Mr. Mikowski's client.
Yeah, Your Honor, this is Dino from Rosio. I'll bring in Gomez now,
Okay.
or I should say Laura's bringing it in now.
Okay, good enough.
Okay, I'll bring that in too.
Thanks.
You're welcome. Bye.
Lisa?
Good morning.
Good morning, Your Honor. May I have a breakout room with Mr. Mann, please?
You're Daniel Antonio Gomez, 269-712-442-FY. Mr. Mikowski, your name?
James Mikowski, P62115, appearing on behalf of Daniel Gomez, is appearing via Zoom.
Mr. Gomez, your name?
Daniel Gomez.
All right. I really would prefer not to go all the way to the 30th. Can you do the 23rd?
I can, but I have to be in Brighton by 12 o'clock. I don't know how the court's schedule is with exams that day.
All right. Let's just, you're sure this is going to exam?
100%.
All right, Mr. Gomez, you have the right to a preliminary exam within 7 days of the date of the probable cause conference. This is the probable cause conference. Your
Okay,
lawyer is
yeah.
requesting that I adjourn this for 3 weeks until June 30. If I do that, that means that the preliminary exam will not take place within 7 days of today's date. Do you understand that?
Yes, Your Honor.
You wish to waive that right?
Whatever my lawyer advised me, Your Honor.
I understand, but I want to make sure. Do you wish to waive that right?
Yes, Your Honor.
Anybody force you to do that?
No, Your Honor.
All right. Preliminary exam will be June the 30th on this at 10 a.m. Elisa, is that good?
Works for me, Your Honor.
Yes, that's
sorry.
good, Judge.
Okay, June 30th at 10, okay?
Thank you. One other issue. My client is asking for the GPS tether to be removed. He's got some ongoing health issues. He's got bulging discs in his back, and it's interfering with his treatment regimen.
I'm going to have to get the prosecutor in here to get their opinion and their argument too. Peace. All right, call him in here. We have 249.
Sorry, Judge.
That's all right.
We need prosecutor for the. Thanks.
Your appearance.
We're not saying anything on behalf of the people, PA 493.
He wants to address bond, Mr. Mikowski. Go ahead, sir.
Your Honor, my client is asking that the tether be removed. He's got herniated discs, bulging discs, and apparently the tether is interfering with his medical treatment that he's taking. He has no wish to contact the complaining witness. Complaining witness lives several cities over.
Is this the one that happened at Grosse Ile where he was allegedly shooting into a crowd of people?
Oh, well, allegedly, yes.
Well, I'm telling you, I felt like I went on my way to give him such a small bond. I'm not gonna delete the requirement of the tether. I don't even need to hear from you. I didn't need to call you in here. So that request, I'm sorry, is gonna be denied, okay? Thank you very much.
Thank you, Aaron.
Have a good day. Thank you.
Thank you.
One more, Tawas Trucking, 26S118458.
Yes.
All right. What is your position with Tawas Trucking, sir?
I am the DOT compliance manager. I'm actually right underneath the president, and he.
I got to have an officer of the corporation do this, sir. Listen. I'm not changing my mind. I can't do it. He's going to have to zoom in. I'll adjourn it 1 week to June the 16th. We'll make it still at 9:15, but he's going to have to zoom in. I don't care if it's the president or vice president, but I have to have an officer. I've been the rule enough on this, and I just can't do it. Okay. So tell the president he's going to have to take 5 minutes. They've already worked it out. If you can get him on the line now, I could do that. He can zoom in.
Yeah, let me, well, you know what? I think he's out of the country right now. I'm sorry.
That's fine. He's going to have to zoom in next week though. Okay.
Okay.
All right. Good enough. Thank you.
Yes, sir. Bye.
Derry, Alonzo, Emmanuel, Mann, 26B712-364. Mr. Mann, your name?
Judge, they're in a breakout room with the attorney.
I'm sorry. I thought this was Mr. Mann.
That's Mr. Butler. His attorney is with the prosecutor right now.
I see. Well, I'm going to take a 5-minute recess here. Okay. So we'll be back in a few minutes. Thank you. Everybody stay seated. You can stay seated, Dan. You want to take your...
What started as a routine court docket quickly turned into a series of tense exchanges as defendants requested special accommodations, bond modifications, and delays in their criminal cases. One of the most notable moments involved a defendant facing serious allegations who appeared in court seeking relief from a GPS tether condition. Defense counsel explained that his client was suffering from herniated and bulging discs and claimed the tether was interfering with medical treatment. The attorney argued that the defendant had no intention of contacting any witnesses and asked the court to remove the monitoring requirement. But the judge wasn't persuaded. After reviewing the nature of the allegations, the judge immediately recalled that the case involved accusations of someone allegedly firing into a crowd of people. The judge explained that he had already approved a relatively low bond, considering the seriousness of the claims, and made it clear he had no intention of removing the GPS monitoring requirement. In fact, before the prosecutor could even respond, the judge denied the request outright. Another hearing involved a defendant who agreed to waive his right to a speedy preliminary examination. The judge carefully questioned him to ensure he understood that delaying the hearing meant giving up an important procedural right. After confirming the decision was voluntary, the court rescheduled the matter for a later date. The courtroom also handled several business-related violations. In one case, a company representative appeared on behalf of a trucking business. However, the judge refused to proceed because the individual was not a corporate officer. Despite explanations about his management role within the company, the judge stood firm and ordered the corporation's president or vice president to appear personally at the next hearing. Throughout the session, the judge repeatedly emphasized accountability and compliance with court procedures. Whether dealing with criminal defendants, attorneys, or corporate representatives, the message remained the same. Court rules exist for a reason, and everyone is expected to follow them. What began as a routine morning docket ended with several defendants learning that convincing a judge to change a court order is often much harder than they expect. Question: if a defendant claims a GPS monitor interferes with medical treatment, should the court remove it, or should public safety concerns come first?